Cohabiting couples are one of the fastest growing family types in the UK. If you cohabit with your partner, it's really important to understand the legal status of your relationship and the consequences of separating from your partner. In particular, the idea of the common law marriage must be remembered as a complete myth. Common law marriage is the erroneous belief that after a certain amount of time living together unmarried will ensure that the law will treat you as though you were married. However, if you are habitually resident in England and Wales, there is no recognition for a committed and dependent relationship unless it has been formalised by marriage or a civil partnership. Non-married couples, for example, are not even automatically each other's next of kin. In other words, married couples and civil partners have certain legal rights and responsibilities upon divorce, whilst cohabitants receive inferior protection or can be treated as unrelated individuals in the separation process. When a marriage ends through divorce, married couples go through an administrative legal divorce process. This, of course, is something unmarried couples do not experience. Assets are divided fairly when people divorce, and generally all assets go into the marital pot. At that point, elements such as the welfare of any children, the needs of the parties, the sharing of the fruits of a married partnership, and compensation on relationship-generated disadvantages are all considered. In addition, the court can redistribute parties' real and personal property and pensions and order one party to make periodical payments called maintenance on divorce. In extreme contrast, unmarried couples have no automatic right to ownership of each other's property when the relationship breaks down. The cohabitants must rely on the general law of contract, property and trusts. And cohabiting couples have no automatic legal responsibility to financially support each other through, for example, periodical payments. The legislation that unmarried couples rely on is incredibly complicated and was not designed for the specific needs of cohabiting couples. For example, for property, the Trust of Land and Appointment of Trustees Act 1996, or TOLATA as we know it, is used when parties are unmarried. Similarly, Schedule 1 of the Children Act 1989 is used for any children under the age of 18 of unmarried couples. These are not easy pieces of legislation to understand, and this therefore makes it vital that cohabitants recognise they do not have the same rights as if they were married to their partner.